As many people know, generally speaking, under the regulation, veterans need a combined disability rating of 70% or greater to include at least one service connected disability rated at 40% or greater in order to qualify for what's known as schedular TDIU. But that's not the only way that veterans can achieve a grant of TDIU. There's something known as extraschedular TDIU. And for extraschedular TDIU, the regulation at issue, which is 38 CFR section 4.16b, allows for veterans to obtain TDIU, but there's a catch, right? As there often is, unfortunately. And that catch is that VA often requires a separate office known as the Director of Compensation and Pension to review the case and issue kind of a preliminary decision as to whether the veteran is entitled to TDIU under this extraschedular rating criteria. So what does that mean in the average veteran's case? It often leads to unnecessary significant delay in the case, sometimes a year, sometimes more than that. But it's significant, right? And so, there's many cases we've had. I can think of one in particular where we developed evidence in the case. We obtained the necessary Form 8940. We did a lay statement. We obtained a vocational expert. I think we even got a statement from an employer. And the case was, we submitted the evidence that we thought was necessary to win the case. Unfortunately, the veteran didn't meet the scheduler requirements for TDIU. But they still, as we discussed, were potentially, they could still potentially obtain TDIU under the extraschedular 4.16b rating. What we saw happen was that prior veterans had their cases remanded to the Director of Compensation, where their case sat for years. So something we've been trying to do is, again, submit a waiver to VA to say, look, the veteran has submitted all the evidence that they think that they need in the case. Do not send the case to the Director of Compensation for a decision. We're okay with you issuing a decision on the merits, up or down, but just issue a decision. Please do not delay the case any significant frame of time. And so that's another way that we can use kind of the waiver to help, not advance, but to help cut down the significant delay in veterans' cases where they're seeking TDIU, but they don't quite meet the rating criteria for it. And if a veteran or the veteran's advocate didn't submit the waiver, they would potentially be sitting at the Director of Compensation's office waiting for some sort of initial decision for months and potentially longer than that.
And another problem too, just to piggyback off of that, is that, as Mike said, if the board remands the case to the Director of the Compensation Service for an opinion about TDIU, if the client meets the criteria under 4.16b only, then not only are we waiting for the director to make that decision, but then we're also waiting for the director's opinion, decision, whatever you want to call it. It's technically not evidence, so call it what you want. Then we're waiting for the regional office to process that information to adjudicate TDIU again. And then if the regional office issues a denial, oftentimes our clients need to return to the board to get a decision because 4.16b TDIU cases can be a little tougher just because that extra schedule or the schedular TDIU criteria isn't met. And so the wait time basically doubles because if you have to go back to the board, you don't achieve your same place in line that you had before. That was a legacy concept that our clients now who are in the AMA do not, they're not afforded that same line jumping, so to speak, option. So people are just kind of put back to the back of the line at the board and are waiting again. And so, as Mike said, we're trying to cut off all of that extra delay that happens once the case is remanded for a director's opinion. And we're trying to, right at the start, submit the best evidence for our clients and submit a waiver that says, we would prefer, frankly, we prefer a denial rather than a remand because a remand means definite wait times. If we get a denial, at least we can quickly appeal. We can have options to appeal either by submitting a supplemental claim or by appealing to the U.S. Court of Appeals for Veterans Claims. But this is something that has been helpful for us The board doesn't always recognize our waiver, and that's a separate issue that we've been needing to litigate. But at the same time, we're looking for any opportunity like this one to make sure that we're cutting out as many extra months and years of delay as possible.
And as I think, veterans know all too well, unfortunately, if their case goes to the director of compensation service, in our experience, it's almost always a denial. So, VA can say that there are built-in procedures and processes in place to protect veterans or to afford them extra review. But in our experience, in many of our veterans' cases, as more just articulated, it really just it leads to unnecessary delay. And if we can do things to get ahead of that, then that's what we're trying to do.